before we begin, I'd like to take a moment to thank our co-sponsors for joining forces with us today. Ryan Azarian Center for Israel Studies and Luskin Development of Public Policy. As you all know, our speaker today is Stephen Zipperstein, someone with a fascinating background, practicing law for more than 35 years, including serving as a US federal prosecutor and as the chief legal officer of two large companies, Verizon Wireless and BlackBerry. Wow. But a few years back, he decided he'd rather be involved in our community. Wow. And so Professor Steve Zipperstein today teaches in the UCLA Luskin Center of Public Affairs, the UCLA Global Studies Program, and the UC Santa Barbara Department of History, and they all love him and more, which we're not even getting into. He is also a senior fellow, we're proud to say, at the UCLA Center for Middle East Development. Now, in addition to these roles, Steve Zipperstein is becoming a prolific writer, and he is now writing 4 books on law and the Arab-Israeli conflict. And you know, when we started this webinar series, which has been so successful and so close to our heart as a result of the pandemic, which we heard of, which we didn't need the pandemic to start this, we started with the first book, and that was Law and the Arab-Israeli Conflict, the Trials of Palestine until 1937. It was a very exciting experience, though I have to say, the numbers signed up today are the highest we've ever had. We've had some really high numbers. Now, for the second one, we'll be discussing today, and this is the book. It's Zionism, Palestinian Nationalism and the Law, 1939 to 1948. It's just out from Routledge, and it's the topic of our talk today. So before I turn this over to our speaker, I just want to say a lot of you are going to have questions because there are a lot of you. And so please, as you've been told before, and we told again, hope you don't get bored with that, please type your questions into the Q&A window found at the bottom of your Zoom screen. And remember, include your full name and country. We won't be able to ask your questions if we don't have this information. So without further ado, Zipperstein.
Thank you very much, Professor Spiegel, for that very kind introduction. Thank you to Manny Jad and the amazing staff at CMed for all the hard work to put this webinar together. And thank you to our co-sponsors, the Azarian Center for Israel Studies and the UCLA Department of Public Policy. Let me put my slides up and we'll be underway. You know, when we think about the Israeli-Palestinian conflict, the law is usually not the first thing that comes to mind, although many of you will correctly point out that the Palestinians especially have been very successful in recent years pursuing legal cases at the International Court of Justice and the International Criminal Court, successfully reframing the essentially political conflict as a legal conflict. But it turns out that for the better part of the last century, and especially during the British Mandate years between 1922 and 1948, all the parties involved, the Arabs, the Jews, and the British, all used the law as a tool, a resource in the conflict to gain leverage against each other and to influence international opinion in the conflict. I wrote about 3 of those trials that occurred in the 1920s and 1930s in my first book, and my second book that we're discussing today covers 4 additional trials between 1939 and 1947. You see them here on the screen. I'll talk about each of them. They each produced different outcomes. In 1939, the London conferences resulting in the one-state solution in favor of the Palestinian Arabs. In 1946, the post-war Anglo-American Committee of Inquiry recommending the no-state solution and continued British trusteeship over Palestine indefinitely. But then a year later, two separate proceedings in the United Nations Special Committee on Palestine, known as UNSCOP, and the follow-on ad hoc Committee on Palestine, both by majority verdict, ruled in favor of the two-state solution. So we'll talk about all of those, beginning with the London conferences in 1939, but I want to start with a little bit of context. And so I will take you back to the third and final trial I covered in my first book, the Palestine Royal Commission, otherwise known as the Peel Commission. You see the members of the commission here photographed behind the King David Hotel in Jerusalem. They conducted months of public and secret hearings in Jerusalem and in London in 1936 and 1937, eventually releasing a 400-page verdict in July 1937 that contained the original version of the two-state solution, the area in orange for the Jews, the area in purple for the Palestinian Arabs, Britain retaining a land corridor from Jaffa to Jerusalem. That was the original proposal for a two-state solution. The Zionist movement reluctantly said yes. The Palestinian Arabs, led by the Mufti Haj Amin al-Husseini, said absolutely no. The British government decided to send a follow-on commission known as the Woodhead Commission to Palestine in 1938 to figure out the details, to figure out how to implement the two-state solution. And while they were there, Prime Minister Chamberlain made his infamous trip to Munich, September 30, 1938, signing this agreement that he's waving here upon his arrival back in the UK with Hitler, declaring there would be peace in our time. And as we all know, unfortunately, that did not happen. A couple of months later, November 9, 1938, that Woodhead Commission sent to Palestine to figure out how to implement the two-state solution, filed its report recommending to the British government that the two-state solution be scrapped. The Woodhead Commission said it would be impractical to implement partition in Palestine. That was November 9, 1938. That same day, by a cruel coincidence of history, that same evening, November 9, was the onset of Kristallnacht, Jewish businesses destroyed throughout Germany, Jewish synagogues burned throughout Germany. Some refer to this as the informal onset of the Holocaust. Well, following those events, in December 1938, the colonial secretary, Malcolm MacDonald, son of the former Prime Minister Ramsay MacDonald, reported to the cabinet in a lengthy memorandum that it was time for Britain to rethink its policy in Palestine. The Arab revolt had been underway from 1936. This is now late 1938. MacDonald recommended that the British government invite delegations of Jews and Arabs, Palestinian Arabs, and Arabs from the surrounding states to come to London in early 1939 for a conference to see if agreement could be reached on the future of Palestine. But MacDonald told the cabinet in late 1938, if the parties can't agree among themselves, then we, the British government, will unilaterally impose a solution for Palestine, keeping in mind that despite the Prime Minister's agreement with Hitler, war with Germany appears to be looming. We need to make sure that we do not antagonize the Muslims in Palestine and the surrounding Arab states and the Muslims in India. India, of course, still under British rule at the time. We need to make sure that we do not drive them into an alliance with Germany. And so our Palestine policy will need to reflect that. So the government issued invitations. The Arabs and Jews came to London for a conference that began on the 7th of February, 1939. The Arab delegation refused to sit in the same room here in St. James's Palace in London with the Jews, refused to even use the same doorway as the Jewish delegation. And so Prime Minister Chamberlain, who you see here in the center, flanked by his Foreign Secretary, Lord Halifax, on his right or left, and then here Malcolm MacDonald, the Colonial Secretary, the Prime Minister had to conduct two separate opening ceremonies. You see here the Palestinian delegation led by Jamal Husseini, the Mufti's cousin, the famed Palestinian lawyer Auni Bey Abdul Hadi, And here, George Antonius, to his right, we'll talk about him more in a second. And then a separate opening ceremony for the Jewish delegation, Ben-Gurion in the middle, Chaim Weizmann to his left, future Israeli Prime Minister Moshe Sharet, then known as Shurtak, sitting over here. The conferences began in earnest through sort of shuttle diplomacy, if you will, conducted by Malcolm McDonald with the separate Arab and Jewish delegations. But very quickly, the Arab side insisted upon receiving a full-blown legal hearing to examine the so-called McMahon-Hussein correspondence that Antonius had published as an appendix to his landmark book, The Arab Awakening, about the rise of Arab nationalism, which had just been published in late 1938. And so the conference really turned into, in many respects, a full-blown legal debate between the Arab side and the British side. The Jews were not invited to participate, regarding whether or not the British High Commissioner in Cairo during World War I, Sir Henry McMahon, had promised Palestine to the leader of the Hijazi Arabs, the Sharif Hussein of Mecca, the great-great-grandfather of the current king of Jordan, Abdullah II, especially in a letter from McMahon to Hussein dated the 24th of October, 1915. And so several full-blown legal hearings were convened. The Arab side hired as their outside lawyer Sir Michael McDonnell, the former Chief Justice of the Supreme Court of Palestine. He retired in 1937, returned to London and was practicing law. He presented the Arab case, made the legal arguments for their case that McMahon had promised Palestine to the Arabs in 1915, a couple years before the Balfour Declaration. The Lord Chancellor of the British government opposed McDonnell in these legal hearings, and ultimately the conferences collapsed without agreement between the Jews and the Arabs on March 15th. And that same day, by another fate of history, German troops marched into Prague, violating the agreement that Hitler had signed with Chamberlain just a few months earlier, and proceeding just a few months on September 1, 1939, the German invasion of Poland and the full-blown launch of World War II. A couple days later, March 17, the conferences in London formally terminated. And on that same day, another coincidence, and I found this telegram buried in a file of correspondence in the British archives in Kew Gardens, London, 17 March 1939, the exact same day that the conferences ended, 2 days after Germany's invasion of Czechoslovakia. This heartbreaking, heart-rending telegram from the Jewish community in Poland, 3.5 million Jews, appealing to the British government to allow the trapped Jews in Poland, next door to Germany, next door to Czechoslovakia, to make their way to Palestine. There is no record whatsoever of any response from the British government to this Jewish telegram from Poland. And unfortunately, by the time the war ended, of those 3.5 million Jews in Poland, only about 75,000 had survived the Holocaust. Well, during the same time, in mid-March, Malcolm McDonald, the colonial secretary, retreated to his country home in Great Waltham and wrote in his own handwriting the first draft of what became known as the White Paper, which was formally issued by the government on the 17th of May, 1939. The White Paper did these three very important things. First, it capped Jewish immigration from Europe to Palestine at a grand total of 75,000 over the next 5 years, an average of 15,000 per year. The purpose was to lock in a 2-to-1 permanent Arab majority in Palestine. Second, the White Paper said that after 10 years, Britain would leave and Palestine would become a majority-ruled single state. This was the original one-state solution in favor of Arabs, Jewish acquisition almost entirely banned as well. But the Mufti rejected this, just as he had rejected the Peel Commission's two-state solution a couple of years earlier. The Mufti saying that he did not want a single additional Jew to be allowed into Palestine, 75,000, therefore was 75,000 too many. Nor did he want to wait the 10 years for independence. He wanted independence immediately. Of course, during World War II, there was not much in the way of negotiation over Palestine. The Zionists held their famous Biltmore Conference in New York in 1942, demanding a Jewish state in Palestine. But the next key event occurred just as the war was winding down. Let me take you to Valentine's Day, 1945, February 14, 1945. We're on board the USS Quincy. Roosevelt had left Yalta, sailed into the Suez Canal, arriving in the Great Bitter Lake for this very, very important meeting with King Ibn Saud. On the left, kneeling in the military uniform, is U.S. Colonel William Eddy, the first U.S. ambassador to Saudi Arabia, who served as translator for the meeting. And FDR made a couple of very important statements to the king. He reaffirmed a secret negotiation or a secret statement he had made in prior talks with the king, saying that the United States would not undertake any moves regarding Palestine without full consultation with both the Arabs and the Jews. And then secondly, during these talks on the Quincy, the Americans and the Saudis really cemented what became a very, very long-lasting relationship, lasting to this day. Roosevelt negotiating for oil rights of passage through the air over Saudi territory, and to show his a sign of friendship between the United States and the kingdom, Roosevelt gave the king an American Douglas DC-3 aircraft with a swivel seat, enabling the king to see Mecca from wherever the aircraft might be flying. 2 months to the day after that meeting, on 14 April 1945, Roosevelt passed away in Warm Springs, Georgia. Truman became president, and immediately the Zionists began pressing Truman to put pressure on the British to allow approximately 100,000 Jews who had survived the Holocaust to be allowed entry into Palestine. Truman sent this fellow here, Earl Harrison, the dean of the University of Pennsylvania Law School, yet another example of lawyers and judges playing a role. Truman sent Harrison to make a tour of the displaced persons camps in Europe, and in July of 1945, Harrison sent a 10-page typewritten memo to President Truman containing this very, very disturbing language on the left, where Harrison says of the American army, "We appear to be treating the Jews as the Nazis treated them, except that we do not exterminate them." That language made a huge impact on Truman, who immediately called on the British government in public to allow the 100,000 Jews to come to Palestine. The British government, which was fearful, of course, before the war of driving the Arabs into an alliance with Germany, was now fearful post-war of driving the Arabs into an alliance with the Soviet Union. Of course, Britain's still worried about the Muslim population in India. And so the Foreign Secretary, you see him here, Ernest Bevin, proposed to Prime Minister Chamberlain and the cabinet. He said, why don't we invite the Americans into the process and hang this on their necks? We can't afford any longer to send massive amounts of troops and money to Palestine. Let's bring the Americans in and make them responsible financially and militarily for whatever the outcome is. Better to have them in the process than to have Truman on the outside criticizing British policy. And so Bevin proposed to the Americans that a special judicial legal committee be created with 12 members, 6 from England, 6 from the United States, co-chaired by judges, populated primarily with lawyers. And so that committee became known as the Anglo-American Committee of Inquiry, created in late 1945, working on a 120-day timeline to issue a verdict to both governments, co-chaired, as I said, by British and American judges. Here's the British co-chair right here, Sir John Singleton, a judge of the King's Bench Division in London. His co-chair next to him, let's take a closer look at him. This is Judge Joseph C. Hutchison, Jr., the Chief Judge of the United States Court of Appeals for the Fifth Circuit, based in Houston, Texas. Judge Hutchison had been shortlisted for the U.S. Supreme Court a few years earlier, but Roosevelt passed him over. Other members of the committee, this is James McDonald, head of the U.S. War Refugee Board during World War II, later became the first American ambassador to the State of Israel, quite sympathetic to Zionism. This is Richard Crossman, a young, brilliant, dynamic Labour Party member of the British Parliament, an unabashed socialist, leaning very heavily against Zionism at the beginning of what I call trial, but by the time it was over, he became very, very much a strong supporter of Zionism and the two-state solution. On the right here is a famed San Francisco lawyer back in those days named Bartley Crum. He was a member of the committee, a Republican lawyer. He headed an organization called Republicans for Roosevelt. Truman put him on the committee. You see him here a couple of years later with his client, the actress Rita Hayworth, who he represented in her divorce from Ali Khan. This is the committee altogether, all 12 of them photographed in Washington, D.C. for their initial round of hearings, which took place here in a conference room in the State Department. I love this photograph from the cover of my book. You see the witness testifying, you see the members of the committee, all engaged in very, very robust cross-examination of the witnesses, especially from the co-chairs here, Justice Singleton and Judge Hutchison. Many famous people testified when the hearings began in Washington, D.C., including Albert Einstein. The committee then made their way to London, where they heard from a broad range of other witnesses, including Lord Herbert Samuel, the first ever British High Commissioner to Palestine at the onset of the mandate in the early 1920s. Of course, Lord Samuel, a Jew, not trusted by the Zionists, who felt that he was not Zionistic enough, and of course not trusted by the Palestinian Arabs because he was a Jew. Here, the committee from London made their way to Cairo for a few days of hearings, and then in those days, of course, you could travel overnight by train from Cairo to Jerusalem. You see them here on their arrival at Jerusalem, photographed. Those of you who have been to the old train station will recognize that. The committee made a tour of the holy sites in Jerusalem, here at the Wailing Wall, here at the Haram al-Sharif, up above the Wailing Wall. The committee staying at the King David Hotel, and you see them here crossing the street, led by the two judges, walking across the street from the King David to the YMCA building, where they conducted their hearings in Jerusalem. Chaim Weizmann testified, Ben Gurion testified, Jamal Husseini testified, Auni Bey Abdul Hadi, who I mentioned earlier, testified. This is Mordechai Eliash, the famed Jerusalem lawyer who was the president of the Palestine Jewish Bar Association. He testified. He eventually became the first ever Israeli ambassador to the United Kingdom. This is Judah Magnus, also originally from San Francisco, California, the first chancellor of the Hebrew University of Jerusalem. He made an impassioned appeal for a single binational shared state between the Arabs and the Jews. The committee loved his idealism, but rejected his ideas as impractical. The famous Jewish philosopher Martin Buber also testified. Golda Meir, then known as Goldie Meyerson, testified. Henry Katan, famous, brilliant Palestinian lawyer, gave evidence, as did Albert Hourani, the tremendously brilliant intellect, Oxford Don. Here's Ahmed Shukeri, the original founder of the PLO in 1964. He testified to the Anglo-American Committee. The Mufti, however, Haj Amin al-Husseini, did not testify. By this time, immediately after the war, he was a wanted war criminal, having collaborated with Hitler, spending the war years in Berlin, broadcasting messages to the Bosnian Muslims, urging them to join sides with Germany. And of course, and we have the documents to prove it, the Mufti also begging the Luftwaffe to bomb Tel Aviv and Jerusalem in 1943 and 1944. Well, after several weeks of taking testimony and cross-examination and receiving documents into evidence, the Anglo-American Committee decided to decamp to the Beau Rivage Hotel in Lausanne, Switzerland, to deliberate their verdict. By this time, the two co-chairs, Justice Singleton and Judge Hutchison were barely on speaking terms. The committee was fragmented and fractured, not just British versus American, but even within the delegations, there were tremendous disagreements. No one thought there was any possibility of the committee reaching a verdict or even a majority verdict. But after 3 weeks of deliberations, the committee somehow managed to reach a unanimous verdict, primarily because of the persuasive powers of Judge Hutchison, and also because of that Member of Parliament, Richard Crossman, who I showed you from the British side, really worked the British side very, very hard to reach a unanimous verdict with the Americans. And they did. And to celebrate the unanimous verdict, Judge Hutchison threw a dinner for the committee on April 18th, the night before they all signed the verdict form. A whimsical menu was created between Judge Hutchison and the chef at the Beau Rivage, featuring, among other things, a choice of Jewish or Arab grapefruit, tourne d'autrement aux champignons bévin, and to drink, Café Haganah and Chateau du Mufti. And all the members of the committee signed on the backside. I found Judge Hutchison's copy of the menu in his papers in the archives at the University of Texas. And here's the unanimous verdict of the Anglo-American Committee. They rejected both the one-state and two-state solutions, opting for continued trusteeship for Palestine. But in a shocking blow to the British government, the committee declared the White Paper of 1939 unlawful. By the way, as of this time, 1946, when the committee rendered its verdict in the spring of 46, the 75,000 quota for Jewish immigration to Palestine that was established in May of 1939 had not even been used up as yet. And the committee, though, declared the White Paper unlawful for limiting Jewish immigration to Palestine and limiting Jewish land acquisition. And the committee also unanimously urged the British government to allow those 100,000 Jewish refugees into Palestine, hopefully during 1946. Well, the British government did not take kindly to the fact that its 6 members of the committee went along with a verdict of that nature. And so the British government decided to invite the Americans to do what? To send yet another delegation to London to figure out how to implement the recommendations or the verdict of the Anglo-American Committee. And on the left here, you see Henry Grady, nice fellow, but somewhat hapless American delegate who went to London to negotiate opposite the Home Secretary, Lord Morrison. And in July of 1946, they came up with a plan that you see on the right, not for a two-state solution, but what they called provincial autonomy. Basically something like, think of Ontario and Quebec in Canada, federal government still under British control for all of Palestine, a green province for the Jews, semi-autonomous, the yellow for the Palestinian Arabs, Britain retaining that same land corridor from Jaffa to Jerusalem, as well as Britain retaining the southern Negev, or most of the Negev, if you will. Well, both sides were completely uninterested, the Jews and the Arabs, in provincial autonomy. And by early 1947, the British government, depleted, exhausted, frustrated, threw the entire Palestine matter into the lap of the United Nations. And the UN took up the challenge, creating the Special Committee on Palestine, chaired yet again by a judge, this time from Sweden, Emil Sandstrom on the right. Lawyers were involved as well. This is Enrique Fabregat from Uruguay in the center. Another judge, Ivan Rand from Canada, was a member of the special committee. A lawyer from Guatemala, Jorge Garcia Granados, wrote a great book about the work of the committee afterwards. The key staffer for the committee was this man here, Ralph Bunche, UCLA graduate, future Nobel Prize winner. Proud to say that our Center for Middle East Development at UCLA is housed in Bunche Hall, named after the great Ralph Bunche. The committee conducted again a trial, again in Jerusalem, again in the YMCA, where you needed a ticket to get in. The same famous Jewish witnesses testifying, Chaim Weizmann. By the way, note, seated behind him, the young Aubrey, future Abba Eben, sitting behind Weizmann, Ben Gurion, testified. This is the way that the witnesses saw the committee from the witness chair. You see Judge Sandstrom there, the chairman in the center. Note, there was a member from Iran on the committee and a member from India. Actually, Pakistan had not yet separated, and so the delegate from India on the committee was actually a judge from Lahore, Pakistan, very, very hostile to the witnesses. However, note that I did not show photographs of any Arab witnesses testifying before UNSCOP, and that's because the Mufti and his cousin Jamal Husseini declared an absolute Arab boycott of the United Nations Special Committee. Many historians view that decision to boycott UNSCOP as really an egregious strategic mistake by the Palestinians. And although no Palestinians participated or cooperated or testified, the committee made a side trip to Amman to visit with King Abdullah, son of the Sharif Hussein of Mecca, who I mentioned earlier, one of the sons, his brother Faisal, future king of Iraq, another son. King Abdullah, of course, the great-grandfather of the current King Abdullah II. Abdullah, very cagey, really played his hand very close to the vest during his discussions with the special committee. We know that, of course, Abdullah was in secret talks around that time with Golda Meir. Abdullah coveted the Palestinian areas of, or the Arab areas of Palestine for himself, for his kingdom, as well as Jerusalem. And he and the Mufti, of course, were on very, very bad terms. Eventually, July 1951, the Mufti had the king assassinated as the king emerged from Friday prayers at the Al-Aqsa Mosque in Jerusalem. Well, UNSCOP, on a majority basis, decided to recommend, again, the two-state solution, just as the Peel Commission had done 10 years earlier. But yet again, another follow-on committee was appointed by the United Nations to look into the details of the two-state solution. This was the Ad Hoc Committee for Palestine, chaired yet again by another judge. This time, Herbert Evatt from Australia served as the chair, and the Ad Hoc Committee reaffirmed on a majority basis the majority verdict of UNSCOP, which was as follows: partition, the two-state solution, one state for the Jews, another state for the Palestinian Arabs. Jerusalem, however, would remain as a corpus separatum, a separate body under international control. And as we'll talk about in a minute, the Jews accepted enthusiastically the recommendation for the two-state solution. The Arabs rejected. And so just to compare to the prior two maps we saw on the left, the Peel Commission two-state solution in the middle, the Morrison-Grady Provincial Autonomy Plan. By the way, here's the UN partition plan on the right. Note the similarity in the Jewish area in orange to the Morrison-Grady Jewish area in green. Very, very similar, but also note that as part of the UN partition proposal, the Jews received the lion's share of the Negev. This was actually far more important to Ben-Gurion, the Negev with the access to the Gulf of Aqaba, the Gulf of Eilat. This was far, and also to have a wedge here, a buffer between Egypt and Jordan, far more important to Ben-Gurion than having control of the holy sites in Jerusalem, although later, of course, as we'll talk about, in the wake of the war of 1948-49, the Israelis ended up with West Jerusalem, the Jordanians, of course, with East Jerusalem and the Old City. The UN Special Committee and Ad Hoc Committee partition proposal came to the General Assembly for a vote, November 29, 1947, Resolution 181. It was extremely tense in the days leading up to the vote. No one was sure how the vote would come out. The US was supportive but not actively lobbying for other votes. The Soviet Union was also supportive but not actively lobbying other members for votes. Finally, at the very end, under direct orders from President Truman, the US delegation was able to convince enough Latin American governments to vote in favor, and the resolution garnered the necessary two-thirds majority in the General Assembly. The Arab reaction was extremely negative. The Arabs renounced and rejected the resolution, began a full-scale civil war on the orders of the Mufti literally the next day on November 30. Note here the reference to a commission appointed, yet another example of a follow-on commission. This time the Palestine Commission was sent by the UN to work out the details of the two-state solution and the eventual end of the mandate. But only a few weeks later, in February of 1948, the Palestine Commission reported to the Security Council, quote, "Powerful Arab interests, both inside and outside Palestine, are defying the resolution of the General Assembly and are engaged in a deliberate effort to alter by force the settlement envisaged therein." On May 14th, 1948, the British government voted to terminate the mandate. The Union Jack was lowered. British troops left Palestine, leaving a vacuum in their wake, which was immediately filled when Ben-Gurion, here at the Art Museum in Tel Aviv on Rothschild Boulevard, now known as Independence Hall, reading the Declaration of Independence in the afternoon of May 14, 1948. The Civil War, of course, was still raging, and immediately the next day, even that evening, the new state of Israel invaded by the armies of Lebanon, Syria, Iraq, Jordan, Egypt, the Egyptian Air Force bombing Tel Aviv the morning of May 15. And by the time the fighting ended through armistice agreements in 1949, early and mid-1949, as you can see, comparing the UN partition plan of November 1947 to where the armistice lines were drawn at the end of the 1948-49 war, the Israelis expanding the territory that had been allocated to them by the UN somewhat. Jordan, of course, ending up in control of the West Bank, East Jerusalem, and the Old City. Only two countries recognized Jordanian sovereignty. Those were Pakistan and Britain. Britain did not extend its recognition to the Old City of Jerusalem, although Pakistan did. And then, of course, Egypt ending up in control of the Gaza Strip. Now, I'm almost done. I just wanted to spend a moment talking about what I view as the very, very important legal consequences of the history that I just went through, which remain incredibly important as we sit here today. I want to preface what I'm about to say by making very clear, lest there be any doubt whatsoever, I want to be very clear that I personally am a very strong supporter of the two-state solution. I believe it is the fairest and most equitable outcome to the conflict, but I believe that it must be achieved through negotiation and diplomacy, because I do not believe that the Palestinian Arabs have a strong legal case for sovereignty, and here's why. The Palestinian Arabs rejected and renounced, as we saw, both the White Paper's one-state solution in 1939, as well as the UN's two-state solution in 1947, just as they had rejected the Peel Commission's two-state solution in 1937. And those rejections and renunciations, as a matter of law, should be viewed as implicit legal waivers of sovereignty over the West Bank and Gaza, which the Palestinians reaffirmed explicitly when they gathered in Jericho for a conference in December of 1950, pledging their loyalty to King Abdullah and expressly waiving sovereignty over the West Bank in favor of the king. In 1964, I mentioned Ahmed Shukeri in the original charter of the Palestine Liberation Organization. The Palestinians once again reaffirmed their prior waivers of sovereignty over the West Bank and Gaza. Let me quote from Article 24 of the charter. The PLO, quote, "does not exercise any regional sovereignty over the West Bank and the Hashemite Kingdom of Jordan or the Gaza Strip." And yet, despite these repeated implied and express waivers of sovereignty over the West Bank and Gaza, today in 2022, the Palestinians argue that they have a legal right to sovereignty over those exact same areas, that they are the legal owners, that they have legal title to those areas. But the history of repeated, implicit, and express waivers undermine the force of that legal claim. And therefore, I believe the legal claim is weak. And as a result, this conflict can only be resolved through politics and diplomacy, not in court through litigation. And so with that, let me conclude. Here are the covers of my two books, the most recent one on the left, the one I spoke to you all about last year on the right. Let me thank you all very, very much for your attention, for your interest in the topic, and I would love now to hear your questions and your comments. Thank you very, very much.
Thank you so much, Steve, for that wonderful presentation. Let me remind you again that you should type your questions into the Q&A window found at the bottom of your Zoom screen. I notice the questions are coming in, so please get yours signed up as quickly as possible, and please be sure to include your full name and country. We won't be able to ask your questions if we don't have this information. Now, as you all are doing that, I have a question. And that question is, in your two books, and right just now in your conclusion, in the second book, you seem to suggest, almost accidentally by the results, that in the first book, Palestinians are doing pretty well. They're kind of convincing the British, who were doing some of the decisions, many of them, most of them actually, that they had a very strong case, and so the move was moving in their direction. But in the second book, the Palestinians don't do well, and by contrast, the Israelis are doing a lot better. Not all of these are really in a legal case the way they were in the first book. How do you explain this difference? First of all, do you agree with me that there was a difference? And secondly, how do you explain the difference in the results for the what became the Israelis, then the Zionists, and the Palestinians, and of course the Zionists weren't so happy either. But do you think there's a big difference, and why?
It's a great question, and yes, there is a difference. In the early days of the legal combat between the parties, the Palestinians did a far better job, especially in the first trial I wrote about, the Shaw Commission of 1929, where Auni Bey Abdul Khadi, who we saw photographed, was the lead counsel for the Palestinian Arab side in this very, very full-blown trial against the Jewish side represented by a British lawyer who Weizmann hired, Sir Boyd Merriman, who traveled to Jerusalem. And I must say that Auni Bey wiped up the floor with Merriman. Merriman did an awful job, was quite embarrassed by the brilliance of the Palestinian legal presentation. And at that time, earlier in the conflict, the view of the British, and so effectively argued by Auni Bey and also through testimony from the Mufti who testified in that trial, the British felt that they had somewhat deceived the Palestinian Arabs through the correspondence between McMahon and Hussein, even though the British government stood by their official position that they had never promised Palestine as part of the areas for post-war independence. Internally, within the Colonial Office and the Foreign Office, the British felt that maybe the Arabs had a legitimate grievance, and so those feelings were reflected in the verdict. But I must say as well, though, it was the result of much, much better lawyering and legal skill brought on behalf of the Palestinian Arabs. As we move forward into the second book, though, times have changed considerably. The Arab Uprising between 1936 and 1939 left the British really quite reeling. On the one hand, very frustrated at the resort to violence. On the other hand, though, very, very nervous and worried about Germany. Ironically, it was the British in World War I who convinced the Arabs to switch sides, rise up against Turkey and join the British. And now on the eve of World War II, the British were afraid that Germany might pull the same thing on Britain and convince the Arabs to rise up against Britain and join sides with Germany. And so against that backdrop, Britain was looking desperately for a way to appease the Arabs, just as they had appeased Hitler in September of 1938, and did that with the white paper. But by the time we get to the post-war, the immediate post-war period, and the presence of the surviving Jewish displaced persons in Europe, and I would also say some really great frustration and anger on the British part with the role of the Mufti during World War II, the Mufti's alliance with Germany, as well as the U.S. administration in Washington, D.C. playing a larger role and keeping, of course, an eye on domestic political circumstances and so forth. The momentum that the Arabs had built legally in their favor in the earlier years began to dissipate significantly, though, and I want to be really clear about this. The first post-war trial recommended the no-state solution, and so people who say, well, the only reason the UN recommended statehood for the Jews was because of the Holocaust, that's wrong, because the first post-war proceeding, the Anglo-American Committee, did not recommend statehood for the Jews. And this was the one that occurred right after the war, when the full knowledge of the Holocaust was becoming known. So I don't attribute the Holocaust to the eventual decision of the UN to go with the two-state solution. The way that I look at this is that by the time we got to the UN Special Committee proceedings, that there was no guarantee whatsoever, and the Israeli historian Elad Ben-Dror has written about this. There was no preconceived outcome whatsoever. The UN did not begin the special committee with any design to create a state for the Jews. One of the huge factors here was an egregious strategic mistake by the Arab side, which I mentioned earlier, which was the decision to boycott the UN Special Committee and not send any witnesses to testify. By the time the ad hoc committee convened in the fall of 1947, September, October, Jamal Husseini realized that they had made a huge mistake by boycotting the special committee, and Jamal Husseini actually testified 3 times before the ad hoc committee, but by that time it was too late. And the majority sentiment in the UN at that time was that the two-state solution represented the fairest outcome.
Okay, I'm glad I asked that question, but let's move on. Questions are building up. And the first one is going to be, I think, the easiest one you're going to get. Mark Anshan of the United States. He says, great presentation. Are these photos in your book?
Yes. All the photos you saw are in the book, except the photo of the Polish Jewish telegram. I mentioned that just in a footnote, but I did not put the photos of that in the book. But I wrote a very long article about the telegram in the Times of Israel a couple of years ago and went into great detail about it. Thank you for the question.
And I'm looking at the questions in order. They all look very good, and this seems the fairest way to do it. We've got Hamid Ahmadi of Iran, and he says, there has been reports that the Committee of 1947 in the UN was more in favor of one federal state solution, so-called the minority view. But during the voting in the UN General Assembly, the votes of some members had been bought in favor of a two-state solution. What do you think in this regard?
Yeah, there's no evidence to support that theory. That's a widely circulated theory that Jewish money or American money was used to bribe the Latin American countries to vote in favor of the two-state solution. There's no evidence whatsoever to support that theory.
All right, now we go to Martha Sklar of the United States. Is there some way I can get a copy of the 3 partition maps? It is helpful to have them when having discussions about the two-state solution.
Yes, we will email them to you. I'll make them available to our staff, and we will be happy to send them to you. Thank you for the question.
Let's go on to Joel Margolis, also of the United States. Why did the Anglo-American Commission of Inquiry reject the 1939 white paper? Was it because the white paper violated the British mandate for Palestine?
Exactly, yes. The verdict goes into great detail addressing the legal requirements that the League of Nations imposed on Britain and that Britain accepted when Britain accepted the mandate from the League in 1922. We're coming up on the 100th anniversary this year, of course. And the committee said that Britain violated its obligation under Article 6, for example, to facilitate Jewish immigration to Palestine under suitable conditions, violated its obligations to facilitate close settlement by Jews on the land of Palestine through the White Paper and the follow-on Land Transfers Ordinance of 1940. And so this was really, quite shocking for Justice Singleton, a proud British judge, and in many ways sort of viewing himself as the representative of the British government on the Anglo-American Committee, for him to go along with a verdict that essentially declared the British government's 1939 White Paper to be illegal was quite shocking to Prime Minister Attlee and Foreign Secretary Bevin.
I want to apologize to anyone if I'm mispresenting your name or anything else. I'm doing my best. We've got people from several countries, and I don't know every language. Anyway, Ferry de Kershove from Grenada. Who were the Palestinians who declared allegiance to Jordan? What status did they have? I like that question because I don't know much about that myself.
Yeah, so there were actually two conferences, one in late 1948 with a smaller delegation of Palestinian leaders, community leaders, civic leaders, religious leaders from throughout the Arab areas in the Hill Country and the West Bank. And then this Jericho conference in 1950, there were 2,000 delegates there who were really caught in the middle between the Mufti and the king. Of course, Jordanian troops had occupied that portion of Palestine since the Israeli Declaration of Independence in May of 1948. And one could say, well, were they really acting out of their free will in declaring allegiance to King Abdullah? All of the evidence supports the notion that, yes, this was a free and voluntary and knowing decision to pledge loyalty to the king based on the resolutions that the Palestinian leadership, and again, these were civic and religious and political leaders from throughout the West Bank, based on those resolutions, the king annexed the West Bank and East Jerusalem, changed the name of the country from Transjordan to the Hashemite Kingdom of Jordan based on the 1950 Jericho Conference. Now, what was the Mufti doing in the meantime? In October of 1948, with a little bit of urging, sometimes more urging and sometimes less urging, but with a bit of urging from the Arab League, the Mufti in late 1948, October of 1948, so this is 6 months after the Israeli Declaration of Independence, the war is raging, the Mufti set up in Gaza an entity called the All Palestine Government, which claimed to be the government in charge of all of what had been British Mandate Palestine, including the new state of Israel, including the areas in the West Bank occupied by the Jordanian forces. The All Palestine Government turned out to be nothing more than a creation on paper. It lasted for about 3.5 weeks in Gaza until most of its less than a handful of ministers picked up and fled to Cairo as the Israeli-Egyptian front began heating up in the third phase of the war in late 1948. The Mufti also eventually left for Cairo. The government had no employees, collected no revenue, had no army, had no territory it controlled, nothing whatsoever. It did manage to print a few passports. There's a photograph of one of those passports in my book. British intelligence reports at the time, which I found in the archives, and CIA reports indicate that the government was nothing more than simply a creation on paper that lasted 3-4 weeks and then vanished. You compare that to what King Abdullah had managed to do, occupying the West Bank, and so it's not a surprise that the 2,000 Palestinian delegates who convened in Jericho in December of 1950 would, as between the Mufti and the king, declare their loyalty to the king.
Next, Max von Kesselstadt from Buenos Aires, Argentina. Thank you, Steve, for a great presentation and congratulations on your new book. Based on the in-depth study of those precedents you described, what is your current view about the two-state solution? Is it still achievable? Or a single shared state with equal rights to both Israelis and Palestinians? What other alternative solutions may help bring stability and peace to these territories and nations?
Gracias, Max. Thank you. Nice to see you. Look, as I said, I do believe the two-state solution continues to represent the fairest outcome for both sides. We're obviously not in a position to make that a reality right now, but that doesn't mean that we should stop trying. I do not believe that the one-state solution is viable in the long term for either side. I think it would be far more problematic. Many people disagree with me, and I respect all the opinions. This is not an obvious answer one way or the other. Look, I think that the two sides have much more to gain as neighbors, maybe not in a warm peace, but at least in the kind of coexistence that you see between Israel, Jordan, Israel, Egypt. And I think the two sides have much more to gain from that kind of relationship than from ongoing occupation and settlement activity and that sort of thing.
Similar question from a mutual friend, Michael Lofty of UCLA. Steve, marvelous presentation. My question is there any hope in your mind for a long-term solution other than a force majeure solution that is one determined by a military balance of power?
Thank you, Professor Lofty. And again, wonderful to have you with us. Look, I hope there is not a force majeure solution. I hope that diplomacy on both sides can yield results. We obviously are on the cusp of new leadership, a new regime in the West Bank at some point. And there's, of course, been a lot of speculation about who might be in the line of succession, what might happen when Abu Mazen parts the scene. And it's anybody's guess at this point what we'll see. Hopefully we'll see something positive occur and not something negative. But beyond that, I, for one, prefer to believe that a diplomacy can help eventually achieve the outcome that is best for both people. And let me just add that in my experiences with the younger people on both sides, I'm really quite optimistic that the younger generation, both on the Palestinian side as well as the Israeli side, they realize they have much more in common. The internet has done a lot. Social media has done a lot. This is sort of the good side of social media, if you will, has done a lot to enable communication and contact, and younger people realizing that they share the same dreams and the same ideals. They want to be part of the future of a world built on technology and startups and innovation. And there are brilliant young people in Gaza, brilliant young people in the West Bank who want nothing more than to be part of this. And they are absolutely as skilled as anyone else, and can very, very easily participate in this kind of economic activity, which hopefully will be a basis for future good relations and cooperation between both sides.
Now we're going to get to something that will particularly interest those of you who are interested in the legal factor. Gary Gilbert of the United States, what are your opinions on two legal principles advanced in favor of Israel's claims to the West Bank, terra nullius and uti possidetis?
Okay, I'll start with, well, I'll take them both together, but I'll address the uti possidetis juris argument, which was advanced by Avi Bell and Eugene Kontorovich in a very lengthy article in the Arizona State Law Review a few years ago. Uti possidetis is a legal principle which basically says that when a colonist leaves a country, that the borders of that country continue as they were under colonial rule. And so the theory is that when Britain pulled up stakes and left Palestine on May 14th, 1948, given that at that moment the Palestinian Arabs had not accepted Resolution 181, had not accepted, in fact, had rejected and renounced the two-state solution. When Britain left, there was a vacuum. The boundaries of Palestine continued as they were during mandatory times, and therefore the new state of Israel inherited those boundaries, essentially stepping into Britain's shoes. And terra nullius is a related concept. The way that I would describe it is that there has been more or less a vacuum of sovereignty. If you don't buy the uti possidetis argument, you say, well, no, Israel did not acquire sovereignty over all of mandatory Palestine as of May 14, 1948. The other argument would be, well, that may be so, but no one acquired sovereignty over the West Bank and Gaza after the British left. And the reason is because the Palestinians rejected the UN's offer. That's an historical fact, an immutable fact. Jordan occupied the West Bank between 1949 and 1967, but only 2 countries in the entire world recognized Jordanian sovereignty. And so that occupation by Jordan did not confer sovereignty on Jordan. And then Israel replaced Jordan as the occupant in 1967 and has remained as the occupant to this very day. And Israel's replacement of Jordan did not confer sovereignty on Israel. And so the legal status of the West Bank, those proponents would say, terra nullius proponents would say, essentially has been that from the moment General Allenby ousted the Turkish army in December of 1917, from that moment until today, 105 years later, the West Bank and Gaza have remained in a vacuum of sovereignty. Sovereignty has been in abeyance, sovereignty suspended. We don't know who has sovereignty over the West Bank and Gaza because sovereignty has never definitively been resolved as a matter of law. And I think that that's probably a well-supported, very fair argument. I reject the argument that sometime between 1967 and today, sovereignty somehow devolved in favor of the Palestinian Arabs. There is no legal basis in international law for that conclusion, although I must say that the International Criminal Court, in its 2-to-1 ruling a year ago almost, February of 2021, the International Criminal Court ruled that for purposes of the Rome Statute, which is the statute that says that sovereign states and only sovereign states have standing to make referrals, criminal referrals to the International Criminal Court, for purposes of the Rome Statute, the ICC ruled 2 votes to 1 that Palestine is a quote-unquote state. And I believe that ruling is incorrect as a matter of law. I think the better argument is that as we sit here today, nobody is the legal owner of the West Bank, not the Israelis, not the Jordanians, not the Palestinians. That's why we need diplomacy and politics, not a court of law or a judge to declare the final status and to award sovereignty. Thanks. That was a really great question. Thank you.
We have about 25 minutes left, and I see we've got loads of questions. So I'm going to start to ask more than one question at a time. And as it happens, we've got several questions about the Palestinians. So I'll combine a couple to be fair to everybody. And these are about the Palestinians. Very interesting set of questions. The first one is from Marina Ingman of the United States. Who are the Palestinian Arabs and how are they different from other Arabs? What were the territories associated with them during the Ottoman control of the territories in question? Lillian Cutler of the United States asks, how is it possible to have a Palestinian state since they are divided into 2 territories with 2 governing bodies?
Okay. On the second question, there have been, of course, proposals to link Gaza and the West Bank. The ill-fated, dead on arrival Trump peace plan had one approach. There have been other approaches. to linking the West Bank and Gaza. The Alone Plan many years ago had provisions about that. And certainly from the Palestinian perspective, the West Bank and Gaza will be the future state of Palestine. At least many mainstream Palestinians believe that. Not Hamas, of course. I'm not talking about them. I'm talking about the PA. And ultimately, this is doable. It's negotiable. There have been different ideas for how to create a corridor that link the two areas, Gaza and the West Bank, land corridor and rail corridor, a tunnel. There have been lots and lots of different ideas. There's no end to the creativity that we can bring to bear to that question. On the first question about who are the Palestinians and what was Palestine during the Ottoman Empire, fascinating question. The Ottomans, the Turks, conquered large areas of the Middle East, including Palestine, in the year 1517, and what we now call modern-day Iraq, Syria, Lebanon, Jordan, most of Saudi Arabia, remained part of the Ottoman Empire for the next 400 years until 1917, when, as I said, British General Edmund Allenby marched his army northward through Beersheba, arriving in Jerusalem in mid-December, Allenby famously dismounting his horse and marching through the Jaffa Gate. In Ottoman times, during those 400 years, the Ottoman Empire was divided into large administrative entities called vilayet in Turkish. And think of a vilayet as kind of sort of analogous to a province in Canada or maybe a state in the United States. And then there were smaller subdivisions within the vilayets called sanjaks. Think of a sanjak as kind of roughly equivalent to a county. Palestine was part of the vilayet of Beirut. Jerusalem and the area around Jerusalem formed its own independent sanjak. In other words, there was no such place as Palestine ever under Turkish rule. And what is very interesting about this is that many of the Palestinian Arab witnesses, and by that I mean Arabs who lived in the area that became known as the Palestine Mandate, agreed by the victorious World War I powers at a conference in San Remo, Italy, in April of 1920, and then codified in the League of Nations mandate in 1922. So people living in Palestine who were Arabs, Christian Arabs, Muslim Arabs, testified repeatedly in the trials that I wrote about in my first book, and even in a couple of the trials in the second book. And I'm talking about Auni Bey Abdul Hadi. I'm talking about the Mufti. I'm talking about George Antonius. All testified, in some cases under oath, that there was no such place as Palestine, that the geographic area that the League of Nations referred to as, quote, Palestine was actually part of Syria and should be called Southern Syria. And in fact, in 1925, Auni Bey Abdul Hadi filed a lawsuit on behalf of a resident of the Palestinian Arab areas of Palestine, call it that, filed a lawsuit demanding that the postage stamps issued by the British authorities in Palestine not use the word Palestine because the area was part of Syria. Now, I don't think that we would hear any Palestinian lawyers or witnesses make that kind of claim today. But in the 1920s and 1930s, that was a very, very common argument made by Palestinian lawyers and witnesses.
We've got so many questions, and I'm trying to combine some to make it fairer to the people who have asked questions. We're going to deal with Jordan next. If the Palestinians have ceded sovereignty of the West Bank to Jordan, could the Jordanians agree to transfer it back to them by means of a simple declaration? Would that not cure their title claim? And the second Jordanian question. It comes from Jonathan Goldberg of the United States. I have never received a persuasive answer to the question of why Jordan, 2/3 Palestinian population, cannot be renamed the Hashemite Kingdom of Palestine, with the U.S. guaranteeing the continuation of the Hashemite Kingdom plus major economic aid. Rights of citizenship in Jordan to all Palestinians living on the West Bank. If Jordan has to have its arms twisted, too bad. That's from Mr. Goldberg. Better than continued Palestinian claims, which will not be realized for generations to come, if at all.
Okay. On the first question, King Hussein, in fact, in 1988 declared that his kingdom would no longer assert administrative or legal authority over the West Bank, but he did not in that declaration purport to confer sovereignty over the West Bank on the Palestinians, nor would it be legally possible under international law, under the Montevideo Convention of 1933, for one country to confer sovereignty over another country, especially when the territory that is at stake here is territory that Jordan did not have sovereignty over. Only two countries recognized it. And so, much like the argument that we heard in response to the Balfour Declaration from many on the Arab side, how could Britain give away something it didn't own, namely Palestine, to the Jews in 1917, or as some of the opponents to the Palestinian position on McMahon Hussein argue, how could the British ambassador, high commissioner in Cairo, promise independence to the Arabs over land that was at that time under Ottoman sovereignty? Likewise, Jordan, the King Hussein, was in no legal position to confer sovereignty, nor did he purport to over the West Bank on behalf of the Palestinians. On the second question, let me address it this way. I mentioned the original League of Nations mandate granted to the British government over Palestine following World War I. That if you look at the map of the original Palestine mandate, the territory that was granted to Britain and that was called Palestine included the modern state of Israel, the West Bank, Gaza, and the entire modern-day Kingdom of Jordan. That was 1922. The Palestine mandate, though, contained a provision that said that the mandatory would have the right in its discretion to divide the mandate along the Jordan River and to cleave off, if it wanted to, the eastern portion of Palestine, which Britain did in late 1923, creating Transjordan as an ongoing British-ruled territory, as a separate entity from the remainder of the mandate on the west side of the Jordan River, which then became known as Palestine. Jewish witnesses who testified before the Peel Commission in 1937 and who testified before the Anglo-American Committee in 1946 and again before the UN in 1947, some of the Jewish witnesses argued, look, Palestine has already been partitioned. The partition was done in late 1923 when Transjordan was cleaved off or split off from the rest of Palestine. And now you're considering a proposal to partition Palestine a second time and to take the remaining western portion, already partitioned, and to cut it in half again, or less than half for the Jews. And that's not fair. But behind the scenes, even beginning with that Peel two-state proposal in 1937, which gave only a very small amount of territory for the Jews, behind the scenes, the Jews were willing to take statehood in even a very small part of that western portion of Palestine. Now, let me fast forward to the 1970s. The Likud won the election. Begin became prime minister in 1977, and we began to hear the refrain from members of the Likud government, Ariel Sharon. We began to hear the refrain that Jordan is Palestine. much like is referred to in the question just asked of me. Jordan is Palestine. And the Palestinians dominate the majority of the population in Jordan. And if Palestinians in the West Bank want statehood, they should cross the river and go over to the already existing Palestinian State, which was part of the original Palestine Mandate. Look, legally, not sure if that is or is not a winnable argument. Politically, it's not a winnable argument. Politically, it's a losing argument. And as I say, I prefer the conflict to be resolved through politics and diplomacy and not through litigation. And so while I understand the question and respect those who have that opinion, I, for one, don't agree that that is a promising path forward to resolving the conflict.
Well, we may have to go a few minutes later. I hope you're agreed. We have so many questions. I'm trying to combine questions as much as possible, and I cannot take two questions from anyone. It's not fair to others. I regret to say we could probably go on all day. Several interesting questions coming up. Eric Altman of the United States, is the correct conclusion to draw from your presentation that the Palestinians cooperated with the AA Commission, but none of the others post-Balfour? Then there's Tagri El-Khadari from Palestine, a very old friend. What is the reaction of the she's not old, but our friendship is. What is the reaction of the Palestinian legal team to your legal argument? And then a very different question, but I think it's related to what you've just heard from Rory Reichart, UCLA political science graduate student. If you believe, why do you support negotiations? So 3 questions around, particularly the last 2 about you. So let's hear.
Okay. In the interest of time, I'm going to go a little bit more quickly. I'll take the second question first. The Palestinian lawyers, Victor Katan, for example, many of there are amazing, brilliant Palestinian lawyers and non-Palestinian lawyers who argue on behalf of the Palestinians at the International Criminal Court and other international bodies, and who publish a lot of scholarship in the area. They would say, look, Zipperstein, just because we said no in the 1930s and 40s, and just because our charter, our original charter, which has been amended many times, said no, that doesn't mean that we are permanently legally estopped, permanently legally forbidden from changing our position. We're the masters of our position, and we have every right to change our mind. And you can't sit there and say that a position that we took decades ago should bind us today. And that's a very, very compelling and very powerful argument. The other argument the Palestinian lawyers make with great frequency is the vast majority of the international community has accorded recognition to the state of Palestine. And we're viewed by the UN General Assembly as a state. So, times have changed. And as we sit here today in 2022, we have achieved statehood. My responses to those arguments are in my book, but I would say just very, very quickly, in terms of the ability to change one's mind or not, yes, of course they have the ability to change their mind, but that doesn't mean that all of their prior renunciations and waivers, implied and express, are no longer relevant. Why? Because Israel relied on those waivers. And it's a basic concept in the law, both domestic and international law in most countries in the world. If one side renounces, rejects, and waives an offer, and the other side goes forward in reliance on that waiver or rejection, then the concept of estoppel, legal estoppel, does arise. And this is the reason why I firmly believe, and this goes to Roi's question, and hello, Roi, I hope you're doing well in Germany. This goes to Roi's question, where I would say, yes, the Palestinian legal case is weak. And I think the Palestinians have done an extraordinarily brilliant job of transforming their political grievances into legal grievances, casting themselves as victims of injustice perpetrated by the Israelis and therefore entitling them to legal remedies like restoration and restitution and rescission. But that's the irony, because their legal case, as I've demonstrated, is weak. So conflating political claims with legal claims at the end of the day is not a winning strategy. I believe firmly that we have to decouple the law from the politics of the situation, and as I said, resolve this without lawyers, without judges, with diplomats at the negotiating table. Once the diplomats make a deal, then yes, lawyers like me can come rushing in. We can write the contracts that reduce the business deals to writing. We can be there if there are contractual disputes. But the role of lawyers and judges is not to resolve this conflict. This is for diplomacy, for people who are expert in statecraft, not lawyers and judges.
Three fascinating questions. Otavia Zwillenberg, a UCLA student. When reading the Polish telegrams, it is hard to not feel sympathetic and deeply understand the Zionist cause. Why has Zionism now become a word plagued by such negative connotations? From Ilya Gukovsky of the UCLA faculty. At the time of the Oslo Accord, did Israel have a different partner authoritative among inside Palestinians to negotiate peace solutions? And then our own Manny Jad, who opened this program, if the various committees you mentioned were to have had a crystal ball to see the region in 2022, do you think they would have done things much differently?
I have to start with Manny's question. That's
yes,
just
of course. What a
fabulous question. And I'm not saying it, Manny, because we're dear friends. I'm saying it because that's a fabulous question.
Fabulous question.
Thank you.
Manny, I'm really, I'm not sure how to answer the question other than to say that if the Mufti had decided to accept the UN General Assembly's two-state solution in 1947, this was the first time that the entire, albeit majority vote, not unanimous vote, but it was the first time the entire world community put the two-state solution on the table. The same solution that many in the Palestinian world firmly desire today. What if the Mufti had said yes in 1947? We might today have two thriving countries next to each other. We might today have beautiful beachfront hotels in Gaza. We might today have a thriving high-tech software industry in Gaza and the West Bank. History could have been very, very different if the Mufti had only said yes in 1947. In terms of Oslo, I should address that. The Palestinians, of course, and this relates to the prior question about the legal arguments that the Palestinians make today. The Palestinians argue that in Oslo, the Palestinians recognized, through their negotiators, recognized Israel's right to exist definitively, kind of giving up the from the river to the sea narrative that unfortunately we still hear today in many quarters. And in return, the Palestinians received not statehood, of course, but at least in Area A, in the main Palestinian cities in the West Bank, a form of, ironically, provincial autonomy in Area A. The Israelis argue that Oslo did not in any way, shape, or form confer sovereignty on the Palestinians, even in Area A, but that Oslo was the beginning of a process that was envisioned to play out over the next 4 years, ending in final status negotiations. And of course, that never happened for a wide variety of reasons that we would spend all day talking about. So I think I'll just stop there.
We have so many great questions, and I know we're going to go a little over, but let me try to deal with as many as possible, as quickly as I can. Chris Bidwell, Another mutual friend. Excellent presentation, Steve. Question, you talked about the history of Jordan and Egypt's respective claims, control on the West Bank and Gaza. Can you speak to historic claims on the Golan Heights during that same time frame? Roz Mandelkorn from the United States, thank you. Was there a fracture within the Palestinian community or wider Arab community that would make an agreement to a two-state solution difficult to successfully create? And another one from an Egyptian American, Michael Tadros. I wanted to ask about how an equitable solution can be reached. Is there anything being done by the UN to stop the development of settlements in the West Bank? Why isn't the UN doing more to ensure some sort of equity between the two peoples?
Okay. The UN is hopelessly compromised, hopelessly biased. Unfortunately, in the conflict, the UN Human Rights Council just recently, very controversially, established a permanent, ongoing commission with one mission to expose alleged Israeli human rights violations, leading to yet more legal cases at the International Court of Justice and International Criminal Court. Those efforts are completely counterproductive by the UN and will do absolutely nothing to achieve a solution to the conflict. It's just more lawfare, as we call it in the industry. And as I argue, it will do nothing to bring a solution any closer. As far as Palestinians who, as I understood the question, might be opposed to a two-state solution, clearly Hamas in control of Gaza since a few months after the Israeli withdrawal. I'm talking now about the 16th year of Hamas control in Gaza. Hamas violently opposed, not just to the two-state solution, but violently opposed to the existence of Israel itself. And I mentioned the fact that we will, at some point in the not too distant future, have a successor to Abu Mazen, Mahmoud Abbas. Hamas would love to take over the West Bank, and that, of course, would spell disaster for those who are in both sides, both for Palestinians who are advocating a two-state solution and for Israelis who are advocating a two-state solution. Although stranger things have happened, for many years it was unthinkable that Arafat would shake the hand of Yitzhak Rabin on the White House lawn, and yet that happened. And so we have to remain optimistic. As far as the Golan Heights, and Chris, very, very nice to have you with us. Hope you're doing well. I don't talk about the Golan Heights in my book. It's really a completely separate issue. Israel, of course, annexed the Golan Heights in 1981, very controversially, during Begin's prime ministership. And the Golan, very, very, from the Israeli perspective, strategic, enormously important area. Syria shelled Israeli settlements from the Golan repeatedly between 1948 and 1967. I think it'd be politically impossible for any Israeli government ever to give up the Golan. But again, Israel and Syria have been in a state of war all these years. Who knows what might happen in the future? But under the Alawi leadership in Syria, and I don't know if Professor Rabinovich is with us or not. He can speak to this much more expertly than me, but I don't see the Assad regime ever, at this point, reaching an accommodation with Israel that would give Israel the confidence, or any Israeli government the credibility to return the Golan.
Michael Burke of the United States, a big question. How is a two-state solution, how can a two-state solution be viable given the proliferation of Israeli settlements sectioning off the West Bank? Dr. Marwa Maziad, Gildenhorn Institute for Israel Studies, University of Maryland. One question, the terms. The PLO does not exercise any regional sovereignty over the West Bank and the Hashemite Kingdom of Jordan or the Gaza Strip might not exclusively mean waiver. It could very well be a descriptive state of affairs, as in practice the PLO does not yet exercise sovereignty to mean practical acts of governance because Jordan annexed this part up in 1967. Did the PLO use Arabic Sayada to sovereignty? And Another big question, Hazim Al-Nimari from Saudi Arabia. I quibble with the argument about sovereignty waivers being binding or at least authoritative over modern day Arab Palestinians. It's fairly established that referendums can be made and remade with different significant outcomes. Case in point, UK membership to the EU, further independence and secession. Interesting. Further independence and secession are now constitutionally catalyzed. I hope you can speak more on the legal value of sovereignty waivers in international constitutional law and whether you might be overestimating its validity.
Yeah, I'll come to that question first. Very, very fair question, for sure. Very fair question. Look, withdrawing from the EU is a lot different. The Lisbon Treaty, exercising their rights under the Lisbon Treaty, which they had the right to do, is very, very different from conferring sovereignty affirmatively on somebody who does not have sovereignty. As I said, sovereignty, the best legal argument that can be made. And by the way, Prince Hassan wrote a small book, a pamphlet about Jerusalem in the late 1970s, making the same argument that Jerusalem, sovereignty over Jerusalem, was in abeyance ever since the onset of the British Mandate. And I would just extend his argument to the West Bank. I think it's the most logical, most sensible argument. Note that I did not adopt Yehuda Bloom's missing reversioner argument for the West Bank. I believe the sovereignty and abeyance argument is the strongest. And therefore, you can't fill that gap with a referendum. You can't fill that gap unilaterally. You can't fill that gap with a proclamation. As a matter of law, that just doesn't work. That does not work under any of the established principles of international law. It requires diplomacy. It requires an international agreement. It just can't happen magically by itself just because we wish it to be the case. Legally, I'm talking about legally. In terms of Article 24, I don't know. I don't speak Arabic, and so I don't know if the Arabic word for sovereignty was used. But I don't agree with the minimalist reading of Article 24 that we just heard. The waiver is very strong, very powerful, very unequivocal, very explicit in favor of Jordan. And I would also point out, and I would love it for someone to correct me if I'm wrong, between 1949 and 1967, the Palestinians in the West Bank never once went to the United Nations, never once made any announcement or request ever indicating that the West Bank belonged to them and that a state of Palestine should be stood up in the West Bank and Gaza. That never happened between 1949 and 1967, ever, other than the founding of the PLO in 1964, when Article 24 said, we're not asserting sovereignty over the West Bank and Gaza. And the reason they said that was because the purpose of the Palestine Liberation Organization, when it was created, was to liberate the portion of Palestine that was known as the State of Israel, to liberate it from Jewish Zionist occupation. And having said that, one of the questions asked about Zionism and why Zionism becomes such kind of a negative concept. I think it ties in directly to the settlement activity that's been ongoing in the West Bank. Of course, in 1975, the UN General Assembly passed an ugly resolution, since rescinded years later, saying that Zionism is racism, an ugly, despicable resolution from the UN. But I do think, though, the settlement activity has created very, very, very bad feelings, of course, very rightly so among the Palestinian population in the West Bank. And the settlement activity, well, I disagree with those who say it's illegal because we don't know the exact status of the West Bank. It certainly has created a political obstacle to peace. The settlements are in the way of achieving a peaceful solution. And that, again, is why we need diplomacy and not litigation to solve the conflict.
So this is going to be our last round. It's very difficult to choose. The questions have been so good, and I really thank all of you. And if there's any that I either that I missed, or you had a second or third question, some of you had more, if you can let us know, we'll get them to Stephen. He will answer these questions. Some of these questions are from friends, and a lot of friends ask questions very late. Michael Yaffe of the United States. Do the Palestinians have any specific counter proposals as to how to solve the issues at hand? Now let's go to Naftali Sabo of the United States. If there is a two-state solution, the creation of the West Bank as a Palestinian state, what happens to the settlers, more than 500,000 people who may fight the authorities to death against the Arab Palestinians and the Israelis on their proper creating a potential civil war? The next one is from someone who I know quite well from Turkey, but I've never been able to pronounce her name adequately. Sima Kalaxioglu. In late 2019, Bibi Netanyahu announced that his government planned to annex the Jordan Valley. Did he have any legal claim for his political attempt then? Would you expect a similar attempt in the future from other Israeli governments? Thanks for this fascinating presentation. And finally, Lois Fishman of the United States. Is a legal matter, why do you think successive rejection of the committee reports act as a waiver of sovereignty claims and not a return to the status quo ante of Palestinian Arab control of whatever lands they held? 4 questions that we could spend hours on. You get a couple of minutes. Take as much as you want, but I just won't be able to ask any other questions. And if anyone else comes in, or those I haven't been able to bring on, I enormously apologize. When you have fantastic questions, it's kind of hard if you're asking them.
So I'll go in reverse order on the last question. The Palestinian Arabs, as I've mentioned, never were the legal owners of the West Bank. The Turks were the legal owners for 400 years. They were defeated in World War I, and ever since the end of World War I, sovereignty has been in abeyance. Sovereignty has been suspended, and so to say that they can sort of revert back to what was theirs, well, it wasn't theirs. Legally, I'm talking about legally. And when you couple that with multiple, not just one or two, multiple renunciations, rejections, and waivers between 1937 and 1964, there are legal consequences that flow from those waivers. Asima, very wonderful to have you with us. Thank you so much. Yes, Netanyahu was talking about annexing the Jordan Valley, and he didn't, because one of the conditions that the United Arab Emirates laid down for the entry into the Abraham Accords in June of 2020 was that annexation be canceled. Netanyahu said he would suspend annexation for 4 years. The new government has not been talking about annexing the Jordan Valley. And so I give great credit to the vision of the Emiratis and the Bahrainis and the Moroccans and the Sudanese for part of the normalization process to extract that concession from the Netanyahu government. As far as the settlers,
I hate to do this, but what she was really asking was, is there anything legal about it if some Israeli government ever tried to do it?
Okay. No, I mean, as I said, there is right now, nobody owns the West Bank. Nobody has sovereignty. And so if Israel were to say, well, we're the occupant, we're going to annex it, would violate a cardinal rule of international law post-World War I, that the acquisition of territory by force is not permissible. Now, Israel would say, we were fighting a defensive war in the Six-Day War. We urged the Jordanians to stay out. King Hussein joined Nasser and the Syrians and attacked us. And in defending ourselves, we pushed the Jordanians out of the West Bank. So it wasn't a war of aggression, it was a war of defense, and therefore we can annex. Asima, the legality, I think, is weaker for annexation, just as it's weaker for Palestinian statehood. And that's because I come back to what I said before, which is that no one owns the West Bank. Settlers are a huge problem, as I mentioned before. I'm not sure, I'll combine Michael's question with the settler question. I'm not sure what proposals behind the scenes. The Palestinian Authority may be willing to consider publicly, of course, the Palestinian Authority's position as Palestinian State along the 1967 lines, with East Jerusalem as its capital. That's sort of the public position right now, which means what for the settlements? It means they would all have to be dismantled. One idea that I have kicked around with some people, many of you may laugh at this, others may think it's interesting, I don't know, but one idea that I've kicked around is why not give the settlers two options. One, you can leave the settlements and go back to the Israeli side, or two, you can remain in the settlements and become dual citizens of Palestine and Israel, and then make the same offer to the Arab Israeli population who live in Al-Fahim and who live in Kalanswa and Taipei and Akko. Make the same offer to them. No one's saying you have to leave Israel, of course, but if you want to become a dual citizen of Israel and Palestine, you can have that right as well. That may be really something that is naive and pie in the sky, or it may be an interesting idea that could provide some fodder for very, very interesting talks around the diplomatic table.
That's exactly the point. I'm so glad. I think you've ended. Do you have anything else you wanted to add? But meanwhile, I want to say, this is the point you put so clearly, and I want to say that I think the people who asked all those wonderful questions, those of you here, added to that, talking about, people say there's nothing to do about the Israeli-Palestinian conflict. And this session showed us there's lots to do and lots to talk about what hasn't been happening in recent years. Steve, do you have anything to add as we close?
I just would like to thank the audience for the amazing questions. That's my favorite part of this sort of webinar, the questions and the comments. Thank you so much. Thank you again, Professor Spiegel, Manny, and the staff and our co-sponsors. It was wonderful to be with all of you.
Thank you. And let me conclude by saying that if anyone is interested in past and future CMIT events, please see your screen or chat window for more information. And of course, you will be able in a couple of days to see this program again. If you want to see it again, or if you have a friend you say, gee, this was a great program, I wish you could have been there. You can be there, can ask a question, but you can be there in the next day or two. Also, before you go, check out the chat window for information on where to purchase Zionism, Palestinian Nationalism, and the law 1939-1948 for a special discount of 30% off. Well, you see what you see, and let me say, on behalf of us all, thank you so much, and bye for now.